I'd also like to introduce our speaker, Frank Daley, who is the Executive Director of the Nebraska Accountability and Disclosure Commission. From 1987 to 1999, he served as the Commission's General Counsel. And prior to his service with the Commission, Daley engaged in the private practice of law in Hebron, Nebraska. He received his BA in government from Seton Hall University in South Orange, New Jersey, and a law degree from Creighton University. Mr. Daley is a member of the Bar Association, and he's also served as chairman of the NSBA's Government Practice Section as president of the Lincoln Bar Association. Please welcome Frank.
Well, thank you very much, Amy, and good morning, one and all. Just so you know, you have materials that you either downloaded or are otherwise available to you. The information that you see on the screen will tell you where we are in the materials, what part of the materials we are covering. So let us say that you are the county attorney of a rural county, and Mega Hog Corporation has just announced it's going to locate the biggest hog operation in the world in your county. It will be submitting an application for a conditional use permit, which in the normal course of events will work its way up to the county board. As you can imagine, there are a lot of strong opinions over the largest hog operation in the world being located in your county. No one is neutral on the matter. And right away, people are starting to look at the county board members who are going to be making the decisions and trying to determine if they're going to make fair decisions. There are already accusations against one county commissioner that he has a conflict of interest because the proposed site of the operation is land owned by his third cousin twice removed. Another county board member is being accused of having a conflict because he has a farm supply business that, among other things, sells pig feed. And everyone is sure that this guy is going to make a fortune if the operation comes into the county. So here's where you are. The local newspaper wants to know if these members have a conflict of interest. The public wants to know if these members have a conflict of interest. The board members want to know if they have a conflict of interest. And heck, you're the county attorney, and even you want to know if they have a conflict of interest. The fact is that any city, any village, any school district, any county, any state agency, any political subdivision or governmental body of any type may at some time find itself at the center of a controversy. It could be because of a proposed mega hog operation, or it could be a chicken plant, or it could be a wind energy project, or it could be a pipeline. But whenever those things happen and governmental decisions have to be made in an emotional context, people right away are scrutinizing both the decisions and the motivations of the public officials and public employees that have to make those decisions. So under those situations, if you are an attorney representing public officials, public employees, governmental bodies, you want to be sure that your folks have the right information so they're not vulnerable and dangling out there. If you're an attorney in private practice and you regularly appear before government bodies or represent clients before government bodies, you want to be sure that public officials and public employees are adhering to the ethical standards that are built into laws, the real ones, not the imagined ones. So in that context, we're going to talk a little bit about some of the ethics obligations of public officials, public employees, including conflicts of interest, interest in contracts, use of public resources, and the like. Let's start out with conflicts of interest. We have to first define what a conflict of interest is, because when you ask the men and women on the street, everyone has a different idea of what a conflict of interest is. We're fortunate we have a definition built into statute that we can work with. So a public official or public employee has a conflict of interest if he or she is faced with taking an official action or making an official decision which could result in a financial benefit or a financial detriment to the public official, a member of his or her immediate family, or a business with which he or she is associated. So again, let's look at that definition again. Public official or employee taking an official action or making an official decision with a financial effect, good or bad, on the official or employee, an immediate family member, or a business with which he or she is associated. So we need to look at some definitions. First of all, we talked about the term immediate family. What's an immediate family member? The term immediate family is a defined term under the Accountability and Disclosure Act, and it is a very, very narrow definition. It would be the spouse of the official or employee. It would be the children of either that are living in the household, or it would be someone who is a dependent for federal income tax purposes of either. So, public official has a spouse, has their children living in the household. The spouse and children are immediate family members. Public official has adult children that live somewhere else. They are not immediate family members. Public official has parents that live somewhere else. They are not immediate family members. This is sometimes a hard concept to convey to the public. On the other hand, perhaps parent of public official is a dependent for federal income tax purposes because of any number of reasons associated with old age. That could be an immediate family member. So you have to look closely at the definition and closely at the situation of the public official or public employee. Okay, next. We talked about businesses and business associations. We have to define the term business, which again is defined under the Accountability and Disclosure Act. And it is a very, very broad definition, unlike the term immediate family member, which is very narrow. It defines business as any corporation, partnership, limited liability company, sole proprietorship, firm, enterprise, franchise, association, organization, self-employed individual, holding company, joint stock company, receivership, trust, activity. Okay, that's pretty darn broad. So just about anything, any association of people is likely to be considered a business except a governmental body which is separately defined. Here's the trap for the unwary. The term business does not distinguish between a for-profit entity and a non-profit entity. So if we're talking about the bank down the street, most of us would recognize that as a business. If we are talking about the convenience store around the corner, most of us would recognize that as a business. But what about the church across the street? Most churches have some sort of corporate or association form. It's an organization of individuals. A church qualifies as a business. What about some of these service clubs that we have? Rotaries or TOMA, Lions, things of that nature. Those are nonprofit entities, organizations, often in corporate form. Those are businesses. So again, be aware that the term business includes for-profit entities and nonprofit entities. All right, so we know what an immediate family member is, we know what a business is, but how does one have a business association with an entity? A person, a public official, public employee has a business association with an entity if the person is an officer, director, limited liability company member, partner, something of that nature, something that gives them an interest in the company or that sort of thing. So officer, director, limited liability company member, if you are one of those, you have a business association with the entity, even if you're not paid. So if you are the president of a nonprofit and you're not paid, it's a volunteer thing, or on the board of directors and you're not paid, you can still have a business association with that entity by virtue of your position. You can also have a business association based upon the holding of stock. So if it's closed corporate stock, family farm corporation or family-held business might have closed corporation stock. If your stock has a value of more than $1,000 or your stock represents an equity interest of more than 5%, you have a business association with that entity. If you are talking about publicly traded stock, if your stock has a value of $10,000 or more or represents a 10% equity interest in the entity, you have a business association with that entity. One of the frequently asked questions is, well, what if I work for a company? I'm not an officer, I'm not a director, I'm not a partner, I don't own stock in the company. Do I have a business association with my employer? And the answer is no, you do not. Mere employment does not by itself rise to the level of a business association. Okay, so other considerations when we're talking about conflicts of interest. I have to remember to click this around. There we go. Other considerations when talking about conflicts of interest. First of all, any financial benefit or detriment must be distinguishable from that experienced by the general public or a broad segment of it. Obviously, this makes sense when county commissioners or city council members or village board members are setting the tax levy for the upcoming year. It's going to affect them as property owners just as it's going to affect everyone else. However, the benefit or detriment is that experienced by the general public, and so that's one of the exceptions to the conflict of interest provisions. The other consideration is the financial benefit or detriment must be reasonably foreseeable. Okay, there has to be a reasonably foreseeable financial effect in order to be there, for there to be a conflict of interest. And the Accountability and Disclosure Commission, in some of its advisory opinions, has said that a financial effect is not reasonably foreseeable if it's remote, speculative, contingent, or uncertain. Okay. There are a number of conflict of interest statutes. They apply to different categories of public officials. Mostly they apply in the same way, but there are some occasional twists. So one of the things you always have to be careful of if you're trying to advise a client in the area of conflicts of interest, that is that you get the right statute. So there's a provision, 491499, that applies only to members of the legislature. 491499.02, which applies to public officials and public employees in the executive branch of state government. And there are other provisions that apply to other categories of public officials and public employees in different political subdivisions. Okay, so now we know what a conflict of interest is. We know what some of the definitions are that surround conflicts of interest. And so now we've got to figure out what is it someone is supposed to do if they believe that they have a conflict of interest. Generally speaking, if a public official or public employee believes that he or she has a potential conflict of interest, they are required to provide a written statement disclosing the action or decision to be taken and describing how they may or may not have a conflict of interest. In other words, describing how an immediate family member may be affected financially, how the public official may be affected financially, how a business association may be affected financially. Okay, so we've got to prepare a written statement. That's an affirmative obligation. Because the Accountability and Disclosure Commission is a government entity, of course, we have government forums to make these disclosures. For the most part, public officials and public employees can use a form aptly entitled Potential Conflict of Interest Statement, Form C2, and those are available on our website. Elected city officials and village officials, except Omaha and Lincoln, and school officials do something a little bit different. For all the other folks that we're just talking about, state employees, state officials, county officials, Omaha and Lincoln officials, they would file their potential conflict of interest statement with the commission. Elected city and village officials, except Omaha and Lincoln, and school officials file their potential conflict of interest statement with the person in charge of keeping records for that particular political subdivision. So in the case of a city, it would be the city clerk. In the case of a village, village clerk. In the case of a school, typically there's some person associated with the superintendent's office that is the custodian of the records. So we think we have a conflict of interest. We've filed something in the right place disclosing that conflict of interest. What happens from there? Well, for members of the legislature, if they file a conflict of interest statement with the commission will simply acknowledge the receipt of the conflict of interest statement and keep it on file as a public record. The statute applying to members of the legislature does not allow the commission to regulate what the member does. So it's simply making a public record of a potential conflict of interest. The member of the legislature files a copy with us, files a copy with the Speaker of the legislature. Other categories of public officials that file with the commission get an analysis by a commission staff member. That could either be me, or it could be our commission's general counsel, Neil Danberg, who happens to be here. Neil, you want to just wave there? Mr. Danberg is here with us today. And what we will essentially do is analyze the filing and send a letter back to the public official or public employee saying something to the effect either, no, you don't have a conflict of interest, you may participate and vote on this matter as you see fit, or yes, you do have a conflict of interest and you need to abstain from participating or voting on this matter. In some cases, when it applies to a state employee in the executive branch, we may actually work with the supervisor to have the matter assigned to another so that the conflict of interest situation is eliminated. Now, cities and villages, except Omaha and Lincoln, they file their statements locally with the person that keeps records for that particular political subdivision, city clerk, village clerk, etc. Once they file that document, they're required to abstain from participating or voting on the matter which they're disclosing in their statement. However, if they want, they can still get an opinion from the commission. If they want to figure out if they actually do have a conflict of interest, they can file it with us, and we will follow the same procedure as we do with other filers. We'll either state that, no, you don't have a conflict of interest, you may participate and vote as you see fit, or yes, you do have a conflict of interest and you need to abstain from participating or voting on that particular matter. Here's kind of a practice tip. Number one, it's important to ensure that when you're advising your public official, public employee, governmental body clients, that you find the right statute that applies. So if there's a filing requirement, it's made in the right place. I think that's one of the attorney nightmares, that you're going to file something in the wrong place at the wrong time. So be very careful about that. If you have any amount of confusion in a specific situation, you can always call us and we'd be happy to tell you what needs to be filed and where. Okay, let's look at a scenario to see how this all comes together. So we've got John, who is a member of the county board, and at the next meeting, the county board will be considering an application by the local chapter of the Order of the Puma for a liquor license to serve alcohol at their clubhouse. John happens to be the vice president of the local chapter, and he carefully considers the matter and concludes, you know what, whether this license is granted or not granted, it's going to have no financial effect on me. And so when the matter comes before the county board, he votes yes in favor of the license. So the question becomes whether or not John has violated the Accountability and Disclosure Act. And under this scenario, the answer is probably yes, because the Order of the Puma probably fits the definition of business. John is the vice president of the chapter, and so he has a business association with that entity. I think most of us could reasonably conclude that being awarded a liquor license is probably a good thing. It will probably have a positive financial effect on the entity, and so therefore John had a couple of obligations. Number one, he had an obligation to file a conflict of interest statement, a written statement with the commission, and he had an obligation to follow our direction, which would have been to abstain from participating or voting on this particular matter. Okay, let's go back a little bit. Let me throw in, I guess, a practice tip. There are times when matters will come before public bodies that you know are emotional. And you may get a glimmer of the fact that someone thinks that members of the public body have a conflict of interest for all sorts of crazy reasons, because members of the public don't typically check the statutes to see what the definition of a conflict of interest statement is. They just think in terms of, oh, is this person's friend, or have they known each other since kindergarten, or things like that. Those things happen. So one of the things you can do is have the person file a conflict of interest statement with the commission, even when you're relatively sure the person doesn't have a conflict of interest, because that gives the commission the opportunity to respond. So think about our mega hog situation, where one county board member has a third cousin twice removed that owns the land, which is going to be the site of the operation, and another board member has a farm supply store that sells pig feed. Well, probably if we were looking at these definitions, we'd say, probably not. But everybody's emotional about this. And so at the meeting where some of these decisions are going to be made and the public's screaming, you have a conflict of interest, and you've got the local reporter from the weekly paper going, conflict of interest, that's a really good one, and all sorts of controversy going on and so forth. Wouldn't it be nice if when that issue came up at the meeting and the board member whose third cousin owns the land is accused of having a conflict, he could say, you know, I had some of the same concerns, and so I filed a statement with the Accountability and Disclosure Commission disclosing that my third cousin twice removed owns this land. And here's a copy of what I filed. And I received a letter from the Accountability and Disclosure Commission stating that having a third cousin twice removed involved in the situation does not constitute a conflict of interest, and so therefore I may participate and vote as I see fit. And here's their letter. I mean, members of the public may not like it, but it probably settles the problem. Or if we're talking about the guy that owns the farm supply operation, well, it's probably a matter of some speculation whether he's going to make any money here. I mean, certainly the thought that there are a lot of pigs nearby may possibly result in him selling more pig feed. But the fact is, when you've got operations that are that big, they probably have some different supply line other than the local feed store. And so it's just as likely that this will do nothing for him. So, you know, that's a matter of some speculation. And so under those circumstances, we'd say he doesn't have a conflict of interest either. So at any rate, remember that those are always possibilities when you're involved in the pipeline or the wind energy project or whatever it happens to be, where everybody's all exercised about what's going on, that you can always get an opinion from us, even if you're fairly certain that your person doesn't have a conflict of interest. Okay. The commission issues advisory opinions. There are a few that are probably kind of pertinent, that are recent, kind of pertinent to public officials and public employees. Advisory opinion number 202, issued in 2017, states it's not a conflict of interest for a county board member to vote for himself or herself for county board chair, even if the position includes a higher salary. So that's one that comes up occasionally. Advisory opinion 203, issued in 2017, states that, number one, a school board member may not vote to pay reimbursement of expenses to himself or herself, and B, a school board member who's also a member of the board of directors of the Nebraska Association of School Boards may not, as a school board member, vote on matters that have a financial effect on the association. Again, because the association is a business and he's on the board of directors, so he has a business association with that entity. And finally, advisory opinion 204, issued in 2018, a county board member who also serves on the board of directors of the Nebraska Association of County Officials may vote on a county budget, even if the budget includes an appropriation for dues, which could later be used to pay dues to NACO. However, the member who's also on the board of directors of NACO may not later on vote to pay the dues to NACO. Again, it's a business association situation. That's sort of a once-over lightly in the area of conflicts of interest. Does anyone have any questions in this area? Yes, sir.
What are the consequences of the action that's taken in a board meeting And it's either void or voidable if it's discovered after the fact that one or more of the members did have a conflict of interest at the time they participated.
Okay, the question is, what is the effect of having a conflict of interest on an action by a board or city council or something of that nature when perhaps without the vote of the person with the conflict, the matter would not have passed or something of that nature? And the answer is, generally speaking, none. In the area of conflicts of interest only. We're going to get into contracts a little bit, and there's some consequences there. But generally speaking, in the area of conflicts of interest, there are punitive actions that can be taken against the board member with the conflict that did not fulfill his or her obligations. But the action of the commission does not, in and of itself, void the action of the county board or the city council or the village board. There may be separate actions that members of the public could take, but that would be outside of our jurisdiction. Okay? Other questions, sir?
What's your practice tip with respect to a conflict of interest that arises during the course of a meeting, but wasn't necessarily anticipated before the meeting occurred? As the attorney, how should we advise that particular member simply recuse themselves from the vote as out of an abundance of caution, or proceed? What do you advise?
Okay. The question is, what happens if during the course of a meeting, the meeting is in progress, and suddenly there's the discovery that someone may have a conflict of interest? And that can happen. A county board member looks at the agenda, sees nothing that particularly comes to mind, and then gets to the meeting, and suddenly there's some sort of presentation being made by an entity where he's got a business association or something of that nature. What do you do under those circumstances? Well, obviously, you can't file something ahead of time to get an opinion. It would seem to me that the best of all worlds is to suggest, hey, when in doubt, you may want to just abstain from participating or voting on this matter. I would also suggest that since there's an affirmative obligation to file a written statement prior to the time the action's taken, and even though you can't do that, it's too late, that maybe the person should file the written statement after the fact. Because I think when push comes to shove, that's the best you can do. And that's substantial compliance. So it would seem to me that obviously it's a judgment call in any meeting that the attorney providing legal advice has to make. But if there's a bona fide belief that there's a conflict of interest, maybe the best advice is to simply suggest, hey, why don't you not participate in this thing? And that's part of the reason for your having these materials and taking this course, so at least you have a sense of what a conflict of interest is. Other questions in the areas of conflict? Yes, sir.
Publicly traded stock. Publicly traded stock.
Okay, we're talking about, the question is, what if there's a business association based upon publicly traded stock, and there's a subsidiary of the entity which may be affected financially by the action or decision of whatever governmental entity you're talking about? And the answer is, darned if I know. It would actually require some in-depth analysis to see, are we talking about a subsidiary which is sort of a department of the main entity? Are we talking about something which is a separate legal entity? Maybe how the money flows back and forth. So the issue would really be the entity in which the employee owns stock, and with which he has a business association. Is there a reasonably foreseeable effect on that entity if there's an effect on the subsidiary? And so that would be the analysis. So a one answer fits all doesn't really work here. Others? Okay, if not, let's move on.
Wait, I have a question.
Okay.
Should the person with the recently disclosed conflict get up and leave the meeting?
Okay, good question. Should the person with the recently disclosed conflict of interest get up and leave the meeting? There's nothing in the Accountability and Disclosure Act that requires that. There is nothing, to my knowledge, in the Public Meetings Law which requires that. I am aware that some political subdivisions build that into their own policies and procedures, but there's nothing statutory that requires the person to leave the meeting. Okay, let's move on then to interest in a contract. Okay. In many jurisdictions outside of the state of Nebraska, the law on having an interest in a contract with your governmental body is really, really easy. It's no, nay, never, you can't have it, absolutely positively prohibited, criminal violation, contracts void. So that's kind of easy in some ways, but the hard part sometimes is catching the folks that care. Nebraska takes a little bit of a different approach. And the reason it takes a different approach is because so much of our state is rural. And so many of our communities are isolated. And the sources of goods and services are relatively limited. Add into that the fact that communities like to do business close to home to keep the money as close to home as possible. It's no surprise that cities and villages want to do business with entities that are within their city or village, and that school districts want to do business with entities that are within the boundaries of their school district. So no surprise there. So Nebraska takes a somewhat different approach to having an interest in a contract with your governmental body. It essentially says that you can't have an interest in a contract with your governmental body unless you jump through certain hoops. There are two statutory provisions that basically deal with an interest in a contract. The first one we're going to talk about is the one that applies to officers in specific political subdivisions. So officers, for our purposes right now, would be a member of an NRD board, a member of a board of any county, school district, city, or village, which spends its own funds, an elected county, school district, educational service unit, city, or village official, a member of the board of directors of a hospital district or county hospital. So we're talking about people in these specific governmental entities that are either elected officials in these entities who serve on boards which spend their own money. And the question I sometimes get is, well, what would be an example of a board that spends its own money that's not the county board or the city council? Well, in some places you have strange combinations of airport authorities that may do that, depending on how they're organized. Sometimes library boards have the authority to spend their own money, things of that nature. Sometimes the rec department, they have a rec board and they raise money through pools, fees, and they spend their own money. That might be an example of something which would be subject to this. Okay, so an officer in these entities may not have an interest in a contract with his or her governing body unless he or she jumps through certain hoops. Here are the hoops. The entry into the contract has to be an agenda item at some sort of open public meeting. So the city council, consideration and action to enter into a contract with Trace Hardware Store for the purchase of whatever it happens to be, a lawnmower. An agenda item. Number two, the officer has to make a declaration on the record of his or her interest in the contract prior to consideration by the governing body. So somehow he has to make a record of the fact that, okay, the city is talking about entering into a contract with Trace Hardware Store to buy a lawnmower. I'm the owner of Trace Hardware Store. He can do this in one of two ways. Number one, he can do it orally at the meeting, and he should take care to ensure that the clerk includes his declaration in the minutes. Number two, he can file some sort of written statement with the clerk or the person that keeps records for the governing body disclosing all of this. I tell people that I recommend doing the written statement because when the public official is doing the written statement, he or she can control the contents. My name is, I own this business. The city council is considering the purchase of a lawnmower from my hardware store. Here's the amount of the purchase price. You can control that. You make a public record. It's there. A lot of city clerks and village clerks, they're usually the most knowledgeable people in local government, but they have different philosophies as to what needs to go into minutes. And so if you're leaving it to the city clerk or village clerk to include something in the minutes, you don't know if he or she is going to get the right stuff in there. So my recommendation is always to suggest that any disclosure of this type be made in writing.
Right, we have
Applies to public officials, public employees, candidates. It applies to members of the immediate family of any of them, and it applies to business associations of any of those individuals. So it's kind of broad in many ways. All right. State employees or state officials in the executive branch of state government are prohibited from accepting, let me just step back. The provision which we just talked about, no quid pro quos, we've always read as saying, okay, you can't accept something of value based upon an understanding that official action would be affected thereby. But there's no general prohibition against public officials and public employees taking gifts. There is no general statutory provision applicable to all officials and employees in state government. So it seems to me that public officials, public employees can legally accept gifts from a variety of sources unless there's a specific statutory prohibition. And the statutory prohibitions are found scattered throughout the statutes and generally apply to a specific category of public officials. By way of example, if you are in the material division of the Department of Administrative Services, there's a specific provision that says you can't accept anything of value from a vendor or a potential vendor. So that's specific as to them. There are some things, I believe, that affect people that work for the lottery that do something similar. But there's no general provision. So generally speaking, public officials and public employees can accept gifts as long as there's no quid pro quo, or unless there's some other specific statutory provision that prohibits it. So right now we're going to talk about one of those specific statutory provisions. This applies to employees in the executive or legislative branches of state government. Essentially, employees and officials in the legislative and executive branches of state government are prohibited from accepting gifts with a value of more than $50 in a calendar month from lobbyists, principals of lobbyists, or someone acting on behalf of either. So, lobbyists. While the legislature's in session, typically during the morning, if you're standing in the rotunda, all those well-dressed ladies and gentlemen are there. You know, most of them are probably registered lobbyists. They're trying to talk with legislators to support legislation, oppose legislation, support amendments, argue for the introduction of legislation, and by law, those folks are registered with the clerk of the legislature's office. The folks that they represent are principals. They're known as principals in Nebraska law, so their clients are principals. People in the legislative and executive branches of state government are prohibited from accepting gifts from lobbyists, principals, or anyone acting on behalf of either that has a value of more than $50 in a calendar month. Now, there are a few exceptions to that. And the $50 rule doesn't apply to food and drink for immediate consumption. So a public official could accept, a few drinks at the bar, but maybe the super duper single malt 50-year-old bottle of whiskey, which has a value of more than $50, will probably not accept that because typically it's not for immediate consumption. There are also some other provisions. Occasional transportation around the state does not count as is not counted against the $50 rule. So lobbyist or principal wants executive or legislative branch official to see their beet processing plant in Morrill County. We're staying within the state of Nebraska, so the $50 rule doesn't apply. And then, of course, tickets to events that are state-regulated events, when the tickets come from a publicly funded post-secondary educational institution, go Big Red, those are okay as well. And just for those of you that are concerned about this, renting the golf cart when you're taking someone to play golf does not count as occasional transportation around the state. Okay. So at any rate, this is a little bit of a trap for the unwary. You know, if you're over in the state capitol, most of the folks over there in the legislative branch, even the executive branch folks, tend to work closely with the legislature. And we're all kind of aware of who the lobbyists are, who the principals are. The lobbyists and the principals here generally are very, very tuned into this $50 limit. And they want to be sure that they're not doing something that's going to cause the office holder to have something blow up in his or her face. So people are very acutely aware of this $50 limit and how it applies and how it doesn't, that sort of thing. The trap for the unwary comes when you are in the executive branch, because if you're over in the state office building or the 1526 building or working for one of the agencies that's not really in the Capitol, who's a lobbyist and who's a principal just really doesn't enter into your world at all. And so you're not thinking of this $50 stuff. And in fact, in many cases, entities that have registered lobbyists aren't thinking about this $50 stuff either. So if you are an advice giver to a state agency of any sort in the executive branch of state government, then just be aware of the $50 rule. If you have a policy where your employees can accept things of value and you don't have any guidelines, at least be aware of where stuff is coming from. You can always check to see if a lobbyist is registered by checking the clerk of the legislature's website.
I have a question.
Yes.
From, let me make sure I get the whole thing. Per 4914, 103.01, subsection 6. You have that memorized, right?
Of course.
If an official is interested due to business association that is party to the contract, but the contract would not provide for a commission or fee, equipment, materials, etc. only, would that still be a conflict?
Okay. We're going back to the
previous
first
Yes.
contractual provision that deals with officers. And the question is, if the public official has a business association with an entity which is interested in the contract, but there's no fee or commission that's changing, and I'm not sure how that would possibly work, but nevertheless, would that still be a prohibited interest in a contract? And the answer is an unequivocal, it depends. And it really depends upon the circumstances of the contract, whether or not there's some value going back and forth. And that needs to be untangled a little bit. So I can't give you a good answer on that because it's so circumstance dependent. Okay, let's move back to the concept of prohibited acts. We've talked about the traps for the unwary and the gifts. Let's talk about the prohibited use of public resources. And let's just stop for a second, Amy. How much of a break did we take there?
We took about 8 minutes. So if you want to take another quick
Okay.
break, you can
I'll
do that.
I'll take a poll here. Do you want to take a quick 5-minute break, or do you want to push on? What's your preference of the folks here at the Ruska Center?
Push on.
I'm getting push on. Okay.
Can I use some water?
No, I'm good. Thank you very much. Okay. Let's talk about prohibited use of public resources. So there are a couple of provisions in the Accountability Act which you ought to be aware of. Generally, public officials, public employees are prohibited from using or authorizing the use of that person's public office or confidential information received through the holding of a public office for personal financial gain other than compensation provided by law for himself, herself, an immediate family member, or a business with which they're associated. Okay, we're back to the official. A member of immediate family is defined. Business association is defined. Essentially, one can't use one's public office to enrich oneself, or use confidential information. So how might that work? Let us say you're on the school board, and informal discussions have indicated for years that ultimately the school is going to have to build a new middle school because the demographic studies show there's this wave coming through and there's just not room. And informally, the board and the staff have talked about a couple of different potential sites. And from your years on the board, you've come to realize that the preferred site is this one out on the highway that's owned by Farmer Joe, who's looking to retire, and the land's not that great for farming anyway. So you use kind of this insider information to purchase that land because you know you can sell it for a lot more to the school district then you're going to need to buy it. You'll buy it at one price, and you'll be able to sell it to the school district for a much higher price. That might be an example of using confidential information for personal financial gain. Or what about using the power of one's public office to achieve some sort of financial gain? What about a situation in which, I don't know, you're a county board member and someone's going to be coming to let's say they sell gravel, and someone's going to be coming to the county board for a special use permit, and it happens to be a guy that sells gravel. You're trying to buy gravel for your driveway, and you're kind of going back and forth negotiating, and essentially at some point you make it clear that if you sell me this gravel at a good price, I'm going to approve your special use permit. I mean, it's sort of a shakedown of sorts, and that would be an example of using one's public office for personal financial gain. Okay, a separate provision. Public official, public employee shall not use or authorize the use of personnel, resources, property, or funds under his official care and control other than in accordance with prescribed constitutional, statutory, or regulatory procedures, and on and on and on. The simplest way to say that is government resources are for government purposes. That's what this provision ultimately means. And so, you have to ensure that government resources aren't being used for private or personal reasons. There's a provision in law, incidental or de minimis use of public resources is not considered a violation. I think the legislature kind of inserted into the law the old legal maxim that lex non curat de minimis. The law does not concern itself with trifles, and I think the legislature is telling the Accountability and Disclosure Commission that we should not concern ourselves with trifles. Okay, public officials, public employees cannot accept lodging or reimbursement for travel or lodging if the gift is made so that a member of the official's immediate family can accompany him on his or her performance of his or her official duties. That's not one that comes up very often. That came up because someone was mad at Governor Johans years ago. There it is. Every piece of legislation has a tail. It's just a matter of whether you're around long enough to understand what the tail is. All right. So let's do a scenario here. We've got Sam Brown. He's a village board member. He owns a home on the edge of town. Sometimes after a heavy rain, his land backs up to a ravine and he gets some serious erosion. So when that happens, he calls the person with the village who generally operates the mini track loader, generic term for a bobcat, I guess, and instructs the employee to use the mini track loader to fill in the eroded area. It normally takes the employee about 30 minutes to accomplish this. Well, this would be an example of a violation of this particular provision of using public resources for personal purposes or for non-governmental purposes. I mean, there's no government purpose being served here. It's because I can instruct this guy to do it, I don't have to pay someone to do it. So this is the type of situation which might be a violation of that particular provision. Government resources can be used for personal purposes by public officials and public employees only in the same manner that members of the public generally can use that resource. So, very simple example, if you're to go to the law library on the 3rd floor of the state capitol, there are 2 copy machines there. One is for state business and the other is for personal business. They're both owned by state government. One of the machines, if I go there to make a copy for business reasons, I can plug in my agency code, get the copies, they'll be billed to my agency at a later date. On the other hand, if I'm trying to make a copy of my tax return or some other personal document, or I'm doing legal research for a private client, if I had any, I would use the other machine where I feed in dimes or quarters or whatever it happens to be. I'm using that state government copy machine for a personal purpose, but I'm using it in the same way as other members of the public use it. I'm not getting a special benefit because I work for government. So that would be okay. That would be an example of where it would be okay. Okay. Are there questions about the use of public resources at all? Seeing none, let's move on. Let's talk about prohibited practices. It's 2018. It's a gubernatorial election year. So let's see. We've got constitutional officers up for election, governor, lieutenant governor, well, not lieutenant governor precisely, secretary of state, attorney general, state treasurer, auditor of public accounts, members of the legislature, members of the board of regents, county board members, city council members. A wide variety of folks are up for election this year. There is a prohibition against public officials and public employees using government resources for the purpose of supporting or opposing the nomination or election of a candidate, or supporting or opposing the qualification, passage, or defeat of a ballot question. And I think we can generally see the wisdom of that. It's one thing for candidates to compete against each other. It's one thing for people to try and get matters on the ballot or convince people to vote yes or no on matters on the ballot. It's another thing to compete against the resources of government if those are all in for the purpose of supporting or opposing candidates or ballot questions. So the concept is simple. The concept is sort of intuitive, that of course that ought to be the law. And now we'll look at all the exceptions that we have to those simple provisions. First of all, there is what I would call the public facilities exception. Generally, it provides that public facilities may be made available for campaign purposes as long as the candidate supported or opposed, or the ballot question supported or opposed, is not an issue in, number one, making the facility available, or the terms or conditions of making the situation or making the facilities available. This is what I often call the school gym exception. If you get to some of our rural areas, sometimes in some of our communities, school facilities are the only ones that are big enough to hold any sort of decent meeting. And certainly if the school wants to make its facilities open to members of the public for a variety of meetings, it's welcome to do so, just as long as they're not saying, gee, the folks that support the school bond can use it, but the folks that oppose the school bond issue cannot. We see examples of this across the street at the state capitol. The Capitol Commission controls the building. And I'm sure you're all aware that occasionally there are rallies held on the front steps of the state capitol. Occasionally candidates announce that they're running for public office in the rotunda of the state capitol. And the Capitol Commission has a series of rules and regulations that are designed to provide access, treat everybody the same, but ensure that there's no disruption of state business, and to ensure that the Capitol is preserved in good condition. So one of the examples might be, if you want to hold an event in the rotunda, you have to use the chairs owned by the Capitol Commission and the tables owned by the Capitol Commission, because they have the right type of feet on there that won't destroy the tile. Or if you want to use the rotunda, there's sometimes restrictions on when you can use it. You can't use it during the period of time that the legislature's in session. So during the legislative session, a lot of events in the rotunda start at noon because the legislature's gone by then. So again, as long as there are rules and regulations that don't restrict people's access because of what candidate they support, what candidate they oppose, what ballot question they support or oppose, then it's perfectly permissible. My favorite was a number of years ago. This involved a school district. There was a school bond issue. The pro-school bond group was asked to use the school gym for some meetings, and the superintendent said yes. After the election was won by the pro-bond issues, the opponents came in and said, that's not fair. They got to use the school gym for their meetings. And the superintendent said, well, you could have used it if you wanted to. Well, we didn't know that. And, well, where's your written policy? Well, there is no written policy. Everybody knows that. So I guess the moral of the story is, if you're representing a political subdivision that's going to allow outside groups, it's not a bad idea to have a written policy, just so your folks aren't vulnerable to an accusation later on that, oh, we were never permitted to use it. By the way, in the school case, the superintendent added that not only does everybody know they can use it, the key is right around the door frame, and the entire community knows you just get the key and you go in. So I guess I love rural Nebraska. Okay, let's see here. Another exception. Governing bodies may discuss and vote upon resolutions supporting or opposing ballot questions. That's kind of a sensible one. And the reason is a lot of times ballot questions emanate from governmental subdivisions. The legislature puts something on the ballot. The city council puts a bond issue on the ballot. There are a variety of things where they come from governmental entities, so it seems appropriate that they ought to be able to discuss it. The other thing is, very often the types of ballot questions that circulate around have a profound effect on political subdivisions. So if we're talking about the property tax relief ballot question that was being circulated, it seems to me that city councils and village boards and school districts might want to weigh in just to let the public know how this would affect the school district or the county or the city. So a limited expression of opinion seems appropriate. Okay, public official, public employee, or public official or employee at the direction of a public official may respond to specific inquiries from the press or public regarding a ballot question. Oh, that seems to be okay. Remember, the legislature is not prohibited from making use of public resources to express his or her opinion about a candidate or ballot question. However, mass mailings are not permitted with governmental resources. I think what they're saying is that legislative members have the opportunity to express an opinion, but you can't really be running campaigns out of the government office. An employee of the legislature who's acting under the supervision of a legislator may use public resources for the purpose of researching or campaigning for or against the qualification, passage, or defeat of a ballot question. Well, I have to admit, researching sort of works for me. Campaigning really doesn't, but I don't get to make the laws. There it is.
I have a question.
Yes.
Because pending legislation in the Nebraska legislature involves neither a candidate or a ballot question, can public officials such as school board provide information to their constituents asking for support of certain legislation?
Okay, the question is, with regard to pending legislation, not with regard to a ballot question, not with regard to a candidate, can a school superintendent ask the public to express support or opposition to the pending legislation? The answer is there's nothing in the Accountability and Disclosure Act which would prohibit that. Okay. A couple of other exceptions. Public officials, public employees, legislators, other than legislators, are not prohibited from doing research on ballot question issues and for the purpose of helping the public body determine if it wants to put the issue on the ballot or not. And there's nothing that prohibits the political subdivision from putting that information on a previously existing website. So if you've got the city of Lincoln that's thinking of putting something on the ballot, it has people in its planning department, its legal department doing research. They put together some colorful brochure, which is for the benefit of the planning commission and the city council. And the idea is that if the city council approves, it would be placed on the ballot. There's nothing which would prohibit the public employees from putting that on the city website so the rest of the public could see that. Public employees may engage in campaign activities except when they're engaged in the duties of their government position. So this is a reflection of a provision in the civil rights section of the state statutes. 20-160 of the state statutes generally provides that public employees have the right to engage in campaign activity except when they're engaged in their official duties. This is sort of a reflection of the same thing. It's saying that the provision prohibiting the use of public resources for campaign purposes does not prohibit public employees from engaging in campaign activities when they're on their own time and not engaged in their official duties. Once again, we have the incidental or de minimis use of public resources for campaign purposes is not considered a violation. Okay, so we've got all of this information. Let's look at a couple scenarios to see how this all works. We've got John Jones, who's a member of the city council. A statewide ballot question will be appearing on the general election ballot next month, which changes the state constitution on the issue of property taxes. By the way, I've been using this example for years. It has nothing to do with what was circulating earlier. Jones believes that city finances would be devastated if the ballot question were to pass. He goes home and uses his personal computer to compose a letter to the editor of the local newspaper. In the letter, he gives 10 reasons to vote no on the ballot question. He urges readers to vote no on election day. Jones prints the letter off on his personal stationery. He signs it, John Jones, city council member. He mails the letter to the newspaper and sends a copy to the chairman of a citizens group, which opposes the ballot question. He suggests to the chairman of the letter, or to the chairman, that the letter be used as the basis of a campaign brochure. So we've got John Jones going home, using his personal computer, pens his letter to the editor, mails it out, signs it John Jones, city council member. He sends it to a campaign person, suggests the campaign person can use this letter for some sort of campaign brochure. So what do you think? Has John violated the Accountability and Disclosure Act in this situation? And the answer is probably not. I mean, the prohibition is against the use of government resources for campaign purposes. He was at home. He was using his own computer. He was using his own stationery. He sent it presumably with his own stamp. And so far, there are no government resources being used, except potentially one. Did anyone catch that?
City council.
Yeah, so he identified himself as a city council member. There was some dispute over this for a number of years. The commission issued an advisory opinion that said, you know, a title is an identifier. It's not a public resource. And later, the legislature actually included it in the statute, so it's very clear now, based upon the statute, that the use of one's government title does not constitute a use of public resources. And again, that makes a certain amount of sense. I mean, think about it. If Governor Ricketts is making a statement with regard to a statewide ballot question, well, you know, I'm not acting as Governor Ricketts right now, but I'm just acting as Pete. And I oppose the ballot. You know, that gets kind of serious. And I think that identifying yourself by your position is not a use of government resources, and the statute makes that abundantly clear. Let's take a separate scenario. We've got Samantha Smith. She's the mayor. And she's been asked by a pro-bond issue group to use the meeting room at City Hall for a meeting of the pro-bond issue group. The meeting room is frequently used for meetings of community groups. By written city policy, the room is made available on a first-come, first-served basis with official city activities taking priority. Outside groups are required to make reservations with the city clerk and pay a $10 fee. Smith states that the group may make use of the meeting room. She directs the chairman to the city clerk to make a reservation and advises the chairman of the $10 fee. So what do you think under these circumstances? It seems to me that under these circumstances, the city has done it right. Number one, it has a written policy. The policy is pretty clear that any community group can use this. Here's what you have to do if you want to use our facility. You have to make a reservation with the city clerk. You have to pay a $10 fee. That's it. And the only other stipulation in there is that city events or official city functions always take priority in scheduling. So under these circumstances, it looks like everybody's done it right, and there's no violation of the Accountability and Disclosure Act. Now, for the most part, there's not very much case law about interpretations of the Accountability and Disclosure Act. I don't know if we run under the radar or if we say something, people accept it as coming from on high. I don't know what it is. But every once in a while, someone challenges us. And that was the case in Vocal versus the Nebraska Accountability and Disclosure Commission. In that situation, we had a complaint filed. And the issue was that Jim Vocal, a member of the Omaha City Council seeking re-election, had been filming videos, campaign videos, in his private government office. So it wasn't one of those spaces out where the public has access to. It was in his private office that theoretically only he had access to. The commission found that that was a violation of the Accountability and Disclosure Act because it was the use of public resources, that is, the private office, for campaign purposes. Mr. Vogel appealed. Ultimately, the Nebraska Supreme Court said, well, that's not really a use. I mean, they were there, but it wasn't a use. So, okay, we're edified by the Supreme Court's opinion. Though I think you should note that Mr. Vogel's decision came down under a predecessor provision to the current provision on use of public resources. The current use is, or the current provision is a lot more specific, and it's also got that concept of de minimis use is not a violation. So be aware of that. Let's see here. We've talked about practice note that public officials, public employees generally not prohibited from engaging in campaign activity while on work time or while engaged in their official duties. So if you've got someone that works 9 to 5 or 8 to 5 and they're engaged in campaign activity at 7 o'clock in the evening, that's probably a pretty good indication that they're doing it at an authorized time. If you've got someone that's doing it on a Saturday and they don't work on Saturdays, again, they're probably good. Certainly public officials, or excuse me, public employees can engage in campaign activity during their normal business hours as long as they're on some form of leave time. So they're on their lunch hour, or they're taking a vacation day or a vacation afternoon, then they can engage in campaign activity if they want to. When we were in the state capitol, we would regularly get visits from legislative staffers and other people working in the Capitol wanting to look at campaign statements filed with our office. And I guess they were hearing some of these seminars because they would announce as they walked in, I'm on my lunch hour. And so that was probably a good thing. The fact that it was 9 o'clock notwithstanding. Okay. The other thing perhaps you need to know is that while there's no restriction on Nebraska state and local officials and employees engaging in campaign activity on their own time, there is the Federal Hatch Act, which is restrictive and applies to some state and local employees. And it is in some ways kind of a big mystery how and when this applies. But the Federal Hatch Act really restricts the campaign activities of state and local employees who are subject to the Hatch Act. Generally, you might be subject to the Hatch Act if you are in a position where you are administering federal grants or enforcing federal grants, or maybe you're holding a position that's paid for in part or in whole with federal funds. So the Accountability and Disclosure Commission does not issue opinions as to whether or not someone falls within the Hatch Act. I have included in the materials a link to the U.S. Merit Systems Protection Board Office of Special Counsel. There's a very good frequently asked questions portion of that where you can find that information. Questions on use of public resources before we move on?
Wait, I do have a question. How about wearing a campaign button at work?
Okay, the question is, how about wearing a campaign button at work, and presumably the person is a public official or public employee? In my opinion, that's engaging in campaign activity. I mean, you are at your workplace promoting a candidate, and it would seem to me that would be inappropriate. So let's look at a couple scenarios. You've got the county clerk that's running for re-election. And when you walk in to the county clerk's office to file a deed or something of that nature, there's a big sign at the counter, re-elect so-and-so. I mean, that clearly is the use of public resources for campaign purposes. Or if you've got your employees, the county clerk got employees wearing buttons that say, re-elect so-and-so for county clerk. Again, people coming in government offices shouldn't be subjected to campaign activity or your campaign opinions. And so it would seem to me that wearing a button would be inappropriate. I'm not sure if we've ever had an advisory opinion that specified that or an enforcement action that specified that. And I think the reason is that most government officials would tell the folks in their office, don't wear that here. And I think that makes sense. The corollary to that was a question we had a number of years ago. Well, what about all the bumper stickers that say so-and-so for president or so-and-so for governor that are parked in state parking lots? Isn't that the same thing? I think it's probably not. A car in a parking lot is different than a public official or public employee serving a member of the public. And I think everybody understands that a car in a parking lot is not government's expression of a campaign position one way or the other. Okay, let's move on. Let's talk about hiring of immediate family members. And right now we're talking about political subdivisions, cities, villages, school districts, and the like. We're not talking about the state level. You recall when we were talking about contracts, we were talking about the fact that public officials could have an interest in a contract with a governing body. And part of the rationale behind the law is that the sources of goods and services are relatively limited in some parts of the state. The same applies to the hiring of immediate family members. In many states, again, the law is pretty simple. You can't do it. One of those no, nay, never, you can't do it within a certain degree of consanguinity. You can't hire relatives. Nebraska takes a different approach. And again, because of the rural character of our state, in many parts of our state, the labor pool is extremely limited. And so if you can't hire family members, you can't hire. And so Nebraska, again, says you can't hire family members, but unless you jump through certain hoops. So let's talk about the hoops here. An official or employee of a political subdivision may hire, supervise the hiring, or recommend the hiring of an immediate family member. We're back to immediate family member, which you remember is a defined term, and that would be the spouse, the children of the spouse, or the official living in the household, or someone claimed as a dependent for federal income tax purposes. Again, a very, very narrow definition. So they can hire an immediate family member if he or she does not abuse his or her official position, and we'll define that a little bit better in a bit. He or she makes a reasonable solicitation and consideration of applications for the position. He or she discloses the matter to the board or the political subdivision. And again, we have forms for that if you'd like to use our form. And when it's an immediate family member, the governing board has to actually approve the hiring. So what constitutes abuse of one's official position? Number one, hiring someone that's not qualified to do the job. I guess an example might be maybe you are a city official. It's your job to hire the lifeguards for the local pool. Your teenage daughter wants to be a lifeguard. She does not have any of the Red Cross certifications in to be a lifeguard or CPR, which is required by state law, but you hire her anyway because she's a pretty good swimmer. Well, she's not really qualified to hold that position. That would be an example. Someone who's paid an unreasonably high salary, that would be an abuse of position. Or someone that's not actually required to show up and do the duties of the position. That would be an abuse of the position. So that's what's required. Reasonable solicitation of applications, disclosure of the family connection, approval by the board, no abuse of position, such as hiring an unqualified person, having an unreasonably high salary, and not requiring the person to actually show up. Okay, so we've got a couple scenarios here. Brown's a village board member. He's in charge of hiring a summer groundskeeper. The main duty of the position is to keep the grass cut on village property. Brown's 18-year-old son just graduated from high school and is looking for a summer job before he heads off to college in the fall. He's qualified to perform the duties of the job. He's been maintaining the grounds around their farm for years using equipment which is similar to the village's equipment. Brown carefully researches the going rate locally for people performing similar duties, so as to ensure that the pay is commensurate with the tasks performed. His son has always been a reliable worker who has worked hard at any job he's ever held. Brown hires his son, files a written statement with the village clerk disclosing that he has hired his son. Okay, so what's right and what's wrong here?
solicited bids.
Okay, yeah, solicitation issue. We don't see any indication that Brown made a reasonable solicitation of applications. Just looked at the duties and said, oh, my son could do this, that'll be okay. So that's a problem. The other problem is that there's no indication that Brown put this before the village board for approval, which is required. So there are two big gaps here. So there needs to be a reasonable solicitation of applications. There needs to be approval by the county board, or by the village board in this case. Even if the village board wouldn't normally approve this position because it's an immediate family member, they would have to. What's a reasonable solicitation of applications? Again, it really kind of depends upon the situation. If the village or the city or whatever it is regularly posts any openings by putting a notice up on the front door of the city hall or village hall, maybe that's reasonable. Maybe if they're putting a notice or ad in the local weekly newspaper, that's okay. I mean, reasonable depends upon the circumstances, how big of a place we're talking about. It just has to be reasonably calculated to give notice to people that the position is available and we're accepting applications. Okay, let's look at another situation. So we may have situations in which you've got someone who's employed by a political subdivision for years and years and years, and then suddenly an immediate family member of that person is elected to the governing board. So the governing board member didn't hire the immediate family member. He or she's been there for years. What happens then? Well, under those circumstances, what's required is the newly elected board member is required to make a disclosure of the fact that I'm on the village board, I'm on the city council, my spouse is, and he or she works in this position for the city or village. That's kind of what's required. So we've got a scenario. We've got Johnson was recently elected to the county board. Her husband has been employed by the county road department for 20 years. On the day she takes office, she files a written statement with the county clerk disclosing that her husband is employed by the county. That's all it takes. She's complied with the law. There's nothing further she has to do on that. Now, there may be times when she has a conflict of interest later on when things come before the county board. We talked about that. So if she's voting to give a 1.5% raise to all of the people in the county road department, that's probably okay. On the other hand, if it's a decision to promote her husband from job A to job B with an increase in salary, that might be something she would need to disclose in a written statement and abstain from participating or voting on. But a question I often get is, well, if she's on the county board, he can't be a county employee. Is that correct? No, that's not correct. I mean, the law makes it pretty clear that that situation is permissible. Okay, questions on hiring immediate family members. Again, what we just talked about applies to political subdivisions, not the state level. Okay. Let's move on to nepotism. When we were talking about hiring immediate family members, it was based upon the concept that you can hire family members because in many parts of our state, the sources of the labor pool can be relatively limited, and so we need to be able to hire family members in order to fill positions. That rationale really doesn't work on the state level because obviously most state employees are based either in Lincoln or Omaha or some of the other urban areas that we have around the state. The bulk of them, not all of them, but most of them. And so that concept really doesn't work. So we have a different set of provisions that applies to state agencies, and actually even more specifically, state agencies in the executive branch of state government. So an official or employee in the executive branch of state government shall not engage in nepotism or act as a supervisor of a family member. We have two things we have to look at. What's the definition of nepotism and what's the definition of family member? Notice it's not immediate family member, it's family member, something different. And that's half the battle in the Accountability and Disclosure Act, figuring out how these statutes apply. Okay, so nepotism, the act of hiring, promoting, advancing a family member in state government, including the initial appointment and transfer to other positions in state government. Okay? Supervisor, an individual having authority to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, discipline, etc., etc., etc. Okay? Family member, not immediate family member, family member. a broader term. Spouse, child, parent, brother, sister, grandchild, grandparent by blood or marriage, so in-laws, or adoption. So immediate family member, child living in the home is an immediate family member. Adult child is not an immediate family member. But family member, adult child, is a family member. So confusing at times, but nevertheless statutory. So, an official or employee in the executive branch of state government who becomes a supervisor to a family member is required to notify the agency head within 7 days. So let's take a situation in which you're a longtime employee at the Department of Corrections. There are a lot of employees at corrections. There are a lot of different facilities at corrections. You have a daughter who's married and so now has a different last name than yours. You're not involved with the hiring process. You supervise a group of about 12 people. If there was a vacancy, it's up to the front office to deal with vacancies. That's not your call. They just assign someone there when they're done filling vacancies. Lo and behold, you come into work one day, and there's your daughter saying, I'm here reporting for work, and you suddenly discover you're supervising your daughter. Your daughter fits the definition of family member. You are now supervising a family member, which means that within 7 days you are required to notify the agency head, I'm supervising a family member. The agency head then has a couple of options. Number one, the agency head can assign one or both of you, maybe one of you. Probably the most logical thing is to put the daughter somewhere else, but that's the agency head's call, such that you are not supervising a family member. The other thing that the agency head can do is determine whether there's a reason for a good cause exception to the nepotism rule. And if the agency head determines that there's good cause, he or she can essentially put something in writing and file it with the Accountability and Disclosure Commission stating, I'm allowing so-and-so to supervise daughter, and here are the good cause reasons why. The commission doesn't look at that. The commission doesn't supervise that. Essentially, it's the agency head taking responsibility for that situation. Most of the time, most agency heads are going to say, no, we don't want to do this. But there might be situations in which it makes sense. Let's say you've got one of those remote Department of Roads sites where you've got a crew that plows the roads, treats the roads, maintains the roads. Say there's a crew of about 15, and you've got the guy that supervises that group. He's in charge of the facility. And lo and behold, one of the people he supervises starts dating his daughter, and a couple of years later ends up marrying his daughter. And so this guy who was not a family member suddenly is a family member because he's a son by marriage, the son-in-law. So under those circumstances, the supervisor has to report to the head of the Department of Roads, or the Department of Transportation now, that I am now supervising a family member. Well, it may be that the Department of Roads head looks at it and says, you know, this is a remote facility. I have no place to transfer anybody to that's within 100 miles. This facility has regularly had a lot of problems getting people to, qualified people to apply and stay at the job because it is so remote. And the other factor is these folks have had a good working relationship for years and years and years before he became a son-in-law. So I'm going to do a good cause exception and file that with the Accountability and Disclosure Commission, and then we'll move on from there. Are there questions about nepotism at all? Probably wouldn't apply to a lot of you. Okay. Let's talk about advisory opinions and staff opinions. The commission obviously is an enforcement agency, but it's also an advice-giving agency. And to that end, we're always happy to talk to you about what the law requires in a conflict of interest situation, interest in contract situation, and so forth and so on. At times, it may be necessary for you to get some sort of written opinion, or one of your people to get some sort of written opinion from the Accountability and Disclosure Commission stating what the law is. To that end, we can do a couple of things. We can issue formal advisory opinions, or we can issue staff opinions. Essentially, a formal advisory opinion is an opinion issued by the commission acting as a body. The Person requesting the opinion sets forth some facts, wants to know how the Accountability and Disclosure Commission affects those facts, or wants to know if they can or cannot engage in a certain course of action under the Accountability and Disclosure Act. The Commission takes a read of that, essentially holds a hearing at which the public can weigh in, and then issues an opinion. That's one way to do it. The opinion is binding upon the Commission until it changes it at some point, and for the person requesting the opinion, it acts as a complete defense against an allegation that they have violated the Accountability and Disclosure Act if they have acted in accordance with the opinion. So, pretty good to have an advisory opinion in your favor. Nevertheless, the downside is this. The Commission needs to issue the opinion as a body. The Commission only meets 6 to 7 times per year, which means depending upon the timing of your opinion request, it may be several months before you get your opinion. And that may not be soon enough for your purposes. So an alternative is a staff opinion. A staff opinion is issued by the staff. In other words, you request a staff opinion, staff reviews it, writes an opinion. Typically, it's within a matter of, depending upon the complexity and so forth and so on, it can be issued in a matter of days or weeks, depending on what the timing of everything is. So typically we will issue staff opinions if it's a simple matter, something that's well settled, or something the Commission has considered in the past, and so there's just not really much of an issue there. So that's a possibility as well. Okay, so let's talk a little bit about the Commission. We've been talking a lot about the Accountability and Disclosure Act. We'll talk a little bit about the Commission itself. So the Commission is a non-code agency of state government. It's part of the executive branch of state government. It's a non-code agency, meaning that the governor does not appoint the head of the agency. He appoints some of the members of the Commission, but he doesn't really have direct day-to-day control of the Commission. So the Accountability and Disclosure Commission, the Accountability and Disclosure Act, requires that the Commission be both politically balanced and geographically balanced. So we have 9 members. One's the Secretary of State. Of the 8 appointed members, there's a limit on how many can be from any congressional district. The idea is that we've got people from the West as well as people from the East. And there's also a limit as to how many can be from the same political party. And there's also a requirement that one of the appointed members be an independent. The members of the Commission are appointed for a single 6-year term. They are not eligible for reappointment. If they are appointed to serve an unexpired term, someone resigns, someone leaves the state, whatever it happens to be, they can then be appointed subsequently to a full 6-year term. So typically our commissioners are serving 6 years, and then they're pretty much done. One unusual situation years ago, we had a commissioner appointed, and within a year she was appointed to the bench and so left. Her replacement served the unexpired term, which was about 5 years, and then was appointed to a full 6-year term. So that was pretty unusual that we had someone that served 11 years. But typically our commissioners are serving 6 years. They're not eligible for reappointment. They serve without pay. There's no per diem. They're entitled to necessary expenses, that sort of thing, mileage, whatever it happens to be. But that's the Accountability and Disclosure Commission. Okay. Let's talk a little bit about the investigation process. You know, if you're really lucky, you never have to be involved in the investigation process, either as the subject of the process or as someone representing a client in the process. But let's talk about it anyway. First of all, investigations. Investigations can be commenced in one of 3 ways. Number 1, through a sworn complaint filed with our office. Number 2, the Commission acting as a body can commence an investigation. Number 3, I as Executive Director have the authority to commence investigations as well. If there's a sworn complaint, it must be signed under oath and allege facts that could constitute a violation of the Accountability and Disclosure Act. So, by way of example, if we receive a complaint alleging that Attorney General Doug Peterson regularly jaywalks on O Street, usually at about 5 o'clock every day, okay, that may be a violation of something, but it's not a violation of anything we enforce, and so we would say that that complaint doesn't state a cause of action. So once the complaint gets past the stage of it states a cause of action, it states something which, if true, could be a violation of the Accountability and Disclosure Act, a pretty low bar. The respondent is notified in writing of the fact that a complaint is filed. He or she is given a copy of the complaint, and they will receive, or he or she will receive notices roughly once every 30 days as to the status of the complaint while it's pending. The person filing the complaint will also receive a notice from us once every 30 days advising them of the status of the complaint. Now, I will tell you that the Commission has a complaint form for use by the public if they want to file a complaint with our office. I will tell you that we do not put our complaint form on our website because once we receive a complaint, it puts us into a process. And we don't really want to be in that process because someone's unhappy that the mayor's dog is running at large on a regular basis, or that someone has violated the open meetings law or the public records law. I mean, those are not things we do. And so our website directs people to contact the general counsel, Mr. Danberg, who I introduced you to. And the purpose of it is to have the person kind of describe what the nature of the complaint is. Because very often, we hear that, well, we think there's a violation of the public meetings law. Okay, the public meetings law is administered, or at least enforced, by either the Attorney General's office or the local county attorney. We have no jurisdiction there. So we're trying to get the person to the right place. Or I was denied public records. Again, that's not us. We try and get people to the right place. If they're filing something, want to file something that no government agency really has any jurisdiction over, we'll tell them that. We will not prevent them from filing a complaint if they want to, but in many cases, if we point them in the right direction, they're happier. Or if we tell them that what they're describing just doesn't fall within the Accountability Act because maybe they're filing a complaint against a private citizen, that they're not a public official, not a public employee, they're not a candidate, they're not running a campaign, they just don't fall within our jurisdiction. If they want to file a complaint, they can. We get rid of it at the probable cause stage, but we try and dissuade them if it's something that just doesn't fall within our jurisdiction. Let's see. Once a complaint's filed, and let us say it gets past the state's cause of action stage, our general counsel, Mr. Danberg, is in charge of the investigation. He either conducts the investigation himself or makes use of various other people that may be of assistance, either a private investigator on occasion. We have auditors within our office that have close to CPA level qualifications. So in some cases where we have to look through books and records, we may make use of them. We may make use of other resources in state government in the course of the investigation. And essentially we do all the things that lawyers often do: investigations, interrogatories, taking depositions, things like that. When the process is complete, when the investigation is complete, Mr. Danberg, our general counsel, will prepare a report, submit it to the Accountability and Disclosure Commission, and the commission will determine if there's probable cause to believe that a violation has occurred. That is there enough evidence to form a basis for believing that the subject of the complaint has violated the Accountability and Disclosure Act? If the answer is no, then the matter typically would be dismissed, or in some cases the commission may direct Mr. Danberg to continue the investigation with maybe some more specific direction. If the answer is that it does find probable cause, then the matter goes on to a hearing. And typically our hearings are before a hearing officer. For many years we used Sam Van Pelt, a retired district judge. We used other retired district judges as well. It's a hearing under the Administrative Procedures Act with some minor modifications because of the Accountability and Disclosure Act. Rules of evidence, as usual, do not apply unless someone requests that they apply. At the conclusion of the hearing officer prepares recommended findings of fact, conclusions of law, and submits them to the members of the commission. The commission will also get a word-for-word transcript of the hearing, including all of the exhibits which were offered into evidence and accepted into evidence, etc. So, Commission has the recommendations, has the transcript of the hearing or the bill of exceptions, and at some point it sits down and deliberates with just members of the commission present. The staff is not present. The staff is not making recommendations. The staff is not communicating with the commission as to what it should do or shouldn't do, that sort of thing. It is the commission itself and the members of the commission that are sitting down and making the decisions. So the commission may adopt the recommendations of the hearing officer. It may change them and adopt something else. But ultimately, it's required to determine if there was or if there was not a violation of the Accountability and Disclosure Act and prepare an order to that effect. If the commission finds that a violation has occurred, it may assess a civil penalty of up to $2,000 per violation. It may enter a cease and desist order directing, essentially saying this practice that caused the violation, you're required to stop. Or it can require the filing of any report or statement that's required under the Accountability and Disclosure Act. So again, the three things it can do: assess a civil penalty of up to $2,000 per violation, enter a cease and desist order, require the filing of any documents that are required under the Accountability and Disclosure Act. Our orders are enforceable by the district court. Our orders are appealable to the district court. Just kind of a war story as to how crazy this can get. Some of you may be familiar with statements of financial interest. Those are the documents that certain categories of public officials and public employees file every year, which disclose their personal resources, sources of income, business associations, things of that nature. It's just the public records. It helps the public detect if there are conflicts of interest or that sort of thing. So they're probably not, for most of us, a big deal. My personal objection to filing a statement of financial interest is that once a year I'm forced to face the modesty of my financial accomplishments. Nevertheless, elected county officials are required to file statements of financial interest. It's statutory. We had a situation years ago where a weed board member in southeast Nebraska had not filed a statement of financial interest. We sent a series of letters without response. We sent a notice of investigation. Wouldn't accept the certified mail. We had to have the sheriff serve. No response. We had an investigation, determined he was on the county board. He hasn't filed. We schedule a hearing. Serve him with notice. He doesn't show. He doesn't have to. Commission, based upon the record, finds that there's the violation. They assess a civil penalty and direct him to make the required filing. We serve a copy of the order on him. No filing. You know, or even calling the county clerk, hey, is this guy still on the board? Is he still around? I mean, oh, yeah. Okay. He shows up at meetings? Yeah. So now we've got this order requiring him to file this statement of financial interest. We've got the civil penalty that's pending. And we're not getting anything done. So we file an action in the District Court of Lancaster County so that we can enforce the order. We file. He doesn't show up for anything. The court orders him to appear. He doesn't show up. We ask for a contempt citation. Court issues it. Orders him to show up. Doesn't. We ask for a bench warrant. Court issues it. We're still not getting a reaction. So about a month goes by. So, I wonder if people down there know about this bench warrant. So I call up the sheriff. I said, Sheriff, do you know so-and-so? Yes, I do. Do you know there's a bench warrant out for him? Huh, there is? Why, I'll have that son of a bitch up in Lincoln by the end of the afternoon. I guess he didn't like it. But, so he got up there, he got an attorney, filed a statement of financial interest, paid a civil penalty, asked the attorney, why didn't the guy file this? It's so simple. He said, well, he was sort of embarrassed that he didn't have anything to report. Go figure. All right. Coming down the home stretch, let's talk about the confidentiality provisions of the Accountability and Disclosure Act. Matters which are under investigation by statute are confidential. And people have a lot of different opinions. There's sort of this thought, how can something called the Disclosure Commission keep this stuff confidential? Is this important stuff? Should the public know? And yeah, I mean, that's a good point. On the other hand, the other rationale is that the people we deal with typically are in public office or they're candidates, and no surprise, there are a lot of complaints that are filed for the mere purpose of embarrassing someone when there's really nothing to it. And so I think the concept was that by making the complaint process confidential, it would discourage people from filing complaints for the simple purpose of harassment. And so what happens is that the complaint itself is confidential when it hits our office. The investigation is confidential. The report of the general counsel is confidential. The action of the commission finding probable cause is confidential, and on and on and on. Our investigations and complaint process only become public if one of two things happens. Either number one, the respondent, the person accused, invokes his or her right to make the matter public, or number two, the commission ultimately finds that there was a violation of the Accountability and Disclosure Act and enters an order to that effect. At that point, everything becomes public. The investigation becomes public, the hearing, the transcript of the hearing, all of those things become public. Now, and again, I think the idea is that it would cut down on the number of frivolous complaints. It has also resulted in some really funny issues. Number one, because people know about the confidentiality provisions, they hold a press conference. I'm filing a complaint with so-and-so about so-and-so because he's done such and such, and it's terrible, and it's outrageous, it's immoral, and I'm filing this with the Accountability and Disclosure Commission. We read about it in the paper, but we never see it arrive. So that's kind of entertaining. In fact, it got to be such a practice that finally we did some research and concluded that it would not be a violation of the confidentiality provisions to respond to a question from the press or public as to whether or not a specific individual has filed a complaint with our office. So if so-and-so is standing here saying, I'm filing a complaint against whatever, and the press wants to know if so-and-so has filed a complaint with our office, we can say yes or no, but we provide no further details. That's it. And that's cut down on that a lot. In fact, there was a situation a number of years ago where there was this group that just kept insisting they were filing a complaint with us. And the press would ask us if so-and-so had filed a complaint. We'd say no, and this went on for 2 weeks, and they were insistent, and they were getting really mad. It turned out that they had attempted to file a complaint via email, but they had used the wrong address, and so they thought they had filed. We never received it. Probably the funniest one is when we had someone call a press conference on the front steps of the state capitol, back when we were in the Capitol, holding up their, I'm filing this complaint with the Accountability and Disclosure Commission, and the cameras are rolling, and here's what this person did, and it's terrible, and, prosecute to the fullest extent of the law and held accountable, on and on and on. And I'm filing it right now. So it was a 60 minutes type of minute where cameras are following along as the person is walking into the Capitol and waiting for the elevator, and everybody squeezes into the elevator, comes out, I'm hereby filing this complaint with the Accountability and Disclosure Commission, and the receptionist looks at it, takes it, timestamps it, throws it in the bin. Press has all these questions. Well, what about the complaint? What about the timing? When it will be? I'm sorry, we can't confirm or deny the filing of any complaint. It made for good television footage. But, for the most part, it probably works because it does cut down on the frivolous complaints that are filed. Okay. We've kind of discussed that the commission has the authority to assess civil penalties. It has the authority to require reports or documents to be filed. It has the authority to enter cease and desist orders. It's also important to be aware that some provisions of the Accountability and Disclosure Act may be prosecuted criminally. There are a number of low-grade misdemeanors that are built into the Accountability and Disclosure Act. I will tell you that the low-grade misdemeanors usually cause county attorneys and the Attorney General's office to have their eyes glaze over in utter boredom at the thought of prosecuting one of those. And in fact, the $2,000 civil penalty is usually higher than the amount of the fine that could be assessed for the criminal prosecution. So we don't have a lot of prosecutions on that. On the other hand, there are a couple there that are felonies, knowingly and willfully filing a false statement required by the Accountability and Disclosure Act could constitute a Class 4 felony. And that's pretty serious stuff. One of the things we started doing on our statements of financial interest is down by the signature portion where the public official signs. It has that language that willfully filing a false statement constitutes a violation of the Accountability and Disclosure Act and could be prosecuted as a Class 4 felony. One of the reasons we do that is because I've been becoming increasingly uncomfortable with some of the statements of financial interest I'm seeing, where apparently they're writing none in a lot of places. They don't have any assets and they don't have any source of income, nothing like that. I worry about folks like that. I think you've got public officials sometimes that just don't take these seriously. And so they file something they know is not complete because it's nobody's damn business, what I have. Problem is they make themselves vulnerable to the person that's opposed to the pipeline, that's opposed to the wind energy project or something like that, because those types of things are going to be scrutinized if they're the decision maker in something which is very controversial. So if you are in a position to advise public officials as to that matter, please be aware of that. Coming down the home stretch, are there any questions about anything we've talked about today? Okay, hearing none. I'll just make maybe a final comment. Really, it's the policy of the Accountability and Disclosure Commission to provide public officials and public employees with the information they need to comply with the provisions of the Accountability and Disclosure Act. While we are an enforcement agency, while we hold hearings and assess civil penalties and do things like that, we really don't want to play gotcha. We consider ourselves realistically to be in the disclosure business. We gather up documents, we gather up information, we make it available to the press and public, and we provide advice to public officials and public employees as to how to comply. We consider that to be our primary role. So if at any time you have questions about how the Accountability and Disclosure Act applies to you or a client or a governmental entity that you provide information or advice to, you're always welcome to give us a call. You can contact Mr. Danberg, you can contact me. We're happy to take your telephone calls, your emails. If it seems that you need something a little bit more formal, we can talk about advisory opinions or staff opinions. We're essentially at your service.
We just got a question in.
Okay.
This is a webcast, she wasn't sure if you covered this. Going back to part 6, interest in contract, it's specifically part C, defining interest in a contract. Board member is a board member is a counsel with large law firm. Governmental entity uses that firm for one specialized area of law. Does this prohibition get to only direct fees or commission to the board member?
Okay. The question is, you've got a board member of a governmental entity who's of counsel to a law firm, and the law firm is used by the governmental entity. The services of the law firm are used by a governmental entity. The question is a little bit complex because of some unknown factors, but let us just say that there's some sort of contractual relationship. Then it becomes necessary to examine what the nature of being general counsel, or excuse me, of counsel is. And I don't know that I'm sufficiently apprised of all of the ways that law firms do that I would know. Appropriately, the situation raises red flags and would require further examination. Okay? Other questions? Okay. If not, I would like to thank the Nebraska State Bar Association for sponsoring this seminar. I extend a special note of thanks to Amy Prenda and Elisa Oria of the NSBA for their work in putting this event together. This concludes today's presentation. Thank you for coming, and have a good afternoon, one and all.